Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7083. Mary Ofisi et al. At balance versus BNP Paribas SA and Al Shamal Islamic Bank. Mr. Dickens for the balance, Mr. Bokudzi for the appellees.
Good morning.
Good morning. May it please the court. The Republic of Sudan entered into a conspiracy with the defendant BNP Paribas and the terrorist organization Al Qaeda to engage in a conspiracy to defeat United States economic sanctions. BNP entered into that conspiracy knowing that funds cleared through that unlawful enterprise, which began in 1997, would be used to support terrorism. For its part in the conspiracy, BNP Paribas created a complex system to elicit U.S. dollar payments, while Al Qaeda used violence. The 1998 terrorist attacks were done in furtherance of that conspiracy. We know this not because of speculation or inference. We know this because Al Qaeda told us themselves that that was one of the stated goals, was to end the U.S. embargo in Sudan. We also know from the criminal trials of the Al Qaeda for the very attack that killed and injured the plaintiffs here in this case, that they used bank accounts within Al Shamal, a bank operating in in Sudan, to fund that attack. Now, these allegations are more than enough to state a claim for conspiracy and aiding and abetting.
Conspiracy and aiding and abetting what?
Well, it's aiding. If we look at it from conspiracy,
everything you said there had to do with defeating the embargo. Maybe they did conspire to defeat the embargo, but that doesn't create a private claim cause of action, does it?
It does under a conspiracy theory, in which
conspiracy has to have a substance a goal that is unlawful, and that's fine. But even though you may have an unlawful attempt to defeat the embargo, that does not give a private claim for relief. Just defeating the embargo does it.
Under the conspiracy, as alleged in this complaint, the agreement that is the focus of the conspiracy is the agreement to defeat United States economic sanctions. That is the agreement entered into by BNP Paribas, by Republic of Sudan.
I'm not believing everything, taking your allegations as true. You still haven't gotten to a private claim for relief at this point, have you? What is the goal of the conspiracy that was accomplished that caused damage to your client?
So the goal of the conspiracy was to defeat those United States economic sanctions. The overt act and the overt act that gave furtherance of that conspiracy, that gave rise to the claim, is the bombing of the embassy. And we know once again that was one of the goals of Al Qaeda, to defeat the United States economic sanctions, as played in the complaint.
That's two different goals. Bombing an embassy and breaking sanctions is not the same thing, is it, counsel?
In a conspiracy under Halberstam, and if we look at Halberstam specifically,
I've looked at Halberstam for years.
I'm sure, Your Honor. What they found was that the civil conspirator can be liable, even if neither planned nor knew about the particular act. But in that case,
but she knew he was engaged in illegal activities, the activities that gave rise to the murder that gave rise to the claim for relief. But here, that was part of the goal of the conspiracy, was to commit the illegal acts that led to his death. But here, you're telling us about a conspiracy to defeat economic sanctions, but I'm not finding a private claim for relief in it.
And from the conspiracy aspect, what gives rise to it, if there is an agreement, and the agreement is here to defeat the sanctions, the injury is caused by an unlawful overt act in furtherance of that conspiracy. And that's where the bombing comes into play, because Al Qaeda, and once again, they told us that one of their goals in furtherance of the conspiracy was to defeat the sanctions. So they agreed and said, we're bombing the embassy because there is this United States economic embargo in Sudan. And once again, that's directly from the mouths of Al-Qaeda. As we're doing this because of this embargo. We're seeking to defeat the sanctions. And that's the same goal that the Republic of Sudan and BNP had. But it's the overt act. Linda Hamilton in Halberstam did not have the goal of the murder of Mr. Halberstam. Linda Hamilton's goal was different. And it was the overt act of the murder which gave rise.
Well, the goal was to conduct the murder was a murder because it was a felony murder, and the felony involved was the goal of the conspiracy. That you had that really was a pretty direct part of the conspiracy. But a conspiracy to conduct the economic transactions here does not have the kind of foreseeability that you had in Haberstam.
Linda Hamilton and Mr. Welch in that case agreed to undertake the legal enterprise of acquiring stolen property. Now, the murder, whether it was foreseeable or not, we put that aside. As long as it was done in furtherance of the conspiracy, that's what gives rise to the cause of action. And here,
how did bombing an embassy help end sanctions?
Well, we don't.
How would anyone think that bombing an embassy would make the United States less likely to put sanctions on?
On a motion to dismiss stage, Your Honor, it's not the goal to whether or not we believe Al-Qaeda in their statement of this is why we did it.
Assume we believe all of this. How does bombing an embassy further a conspiracy, as far as we know, the conspiracy the bank entered to defeat economic sanctions?
Well, I don't think we need to get to the state of mind of Al-Qaeda and their basis, but if we do...
I think you need to get somewhere that makes this bank a conspirator in a conspiracy to commit the embassy bombing in order to have a private claim for relief. And I'm exploring how you get there, and I'm not getting very far.
Al-Qaeda told us, right, that here are the reasons why we're bombing the attack. And this sets a case away from the Bernhardt case, which was decided, in which the court looked at the specific reasons. In that case, a bombing of a small secret CIA camp, it was completely implausible that it would be based on, they would be doing that act to defeat the United States. Here, it's different. This is a widespread attack in which they focused, and we have fled from 1997 that bin Laden was talking about the U.S. embargo, about what he was going to do with respect to that, and undertook these efforts to bomb the attack, to defeat those sanctions. Now, we don't have to say, okay, that doesn't seem right in my mind. That was what Al-Qaeda specifically did, to chase Americans out, to kill them, to make them withdraw their sanctions.
Mr. Diggins, how can you distinguish the facts here from Owens? I mean...
And it's a good question, Judge Rao. This case is not Owens, and it's not Owens in either allegations pled or the cause of action raised. And so the Owens...
We know it's not Owens, but how do you get around Owens as precedent?
Yeah, so Owens, in looking at the allegations there, Owens didn't contain any allegations regarding al-Shamal or the use of Al-Qaeda accounts in al-Shamal prior to the attacks. It contained no allegations of Al-Qaeda's use and reliance on Sudanese banks prior to the 1990 embassy bombings. It contained no publicly available reports tying Sudan to Al-Qaeda.
And why do those things make a difference?
Well, those things make a difference. One, because they didn't allege, and the next step of it is they didn't allege any secondary liability. They only did through the ATA claim, but the court determined, based on the older version, that secondary liability wasn't available at that stage. And so there were no secondary liability for conspiracy and aiding and abetting. These elements of that I just stated are relevant to general awareness under aiding and abetting. It's relevant to, once again, the furtherance of the conspiracy, but it's also relevant to knowledge and the close proximity or the close ties between BNP, al-Shamal, as well as the Republic of Sudan. So al-Shamal here was not a Sudanese entity. It was a separate intermediary, and we must look at those intermediaries separately. see them running out of time. If I can save any time I have left. Thank you.
Thank you.
Good morning, and may it please the court. Carmine Bacuzzi from Cleary Gottlieb for the appellee BNP Paribas. The district court was correct in dismissing the complaint. The correctness of its ruling was confirmed by this court's decision in Owens, as well as this court's decision in Bernhardt, the Second Circuit's decision in Rothstein, which Owens followed, as well as the Seventh Circuit in Kemper and many others. In this case, there is no pleading of any meeting of the minds between BNP Paribas and Al-Qaeda. There's actually nothing pled about any connection between BNP Paribas and Al-Qaeda. The complaint does not plead that BNPP was banking al-Shamal. It doesn't plead that it was aware of any connection between al-Shamal and Al-Qaeda. It doesn't even plead in a non-conclusory way that BNP was aware that Al-Qaeda was working with Sudan. Just as in Rothstein, there's no pleading that BNPP was a participant in any attack. There's no pleading that any money had any connection to the attack. And there's no pleading that any money directly went BNP to Al-Qaeda. With no well-pleaded allegations, the court was correct to dismiss the ATA claim, just as in Owens, for failure of proximate causation. As to conspiracy, there is no common goal. Judge Sentelle, your questions are absolutely right. It's clear that BNPP, like the banks in Bernhardt and in other cases, was acting to evade sanctions for a profit motive. They say, oh, we're all agreed on defeating sanctions, but defeating sanctions is just a characterization on their part for Al-Qaeda committing murder to get the United States to back off of sanctions. But that, of course, in complaint paragraph 3, is explicitly said not to be the aim of BNP Paribas. It says BNPP did not share the intent of Al-Qaeda to commit any murder, to harm anyone. So the conspiracy claim fails for that simple reason, as well as in Bernhardt, where the court said, where is the act in furtherance of the conspiracy?
So can I ask you about your characterization of the Jesner case, the Supreme Court's case in Jesner? You suggest that that is a bar to jurisdiction here. But as I read that case, it's really about a cause of action. And so I'm wondering why you read it as a jurisdictional bar.
Is this that's the ATS claim?
Mm-hmm.
Yes, whether the Supreme Court has often said Jesner is jurisdictional, but also you're correct, Judge Rao, it's bringing in this cause of action for an international law tort. And so in that way,
I mean, it's a
like
threshold. It's a threshold issue, but is it a jurisdictional one?
I think it is a jurisdictional issue, but either way, it's an issue that came up after the decision by the district court judge, which is why we raised it on appeal as a complete bar to this claim, because Jesner says you don't have a cause of action. There is no jurisdiction in U.S. courts for a claim like these claims against a foreign bank, foreign corporation. That case was decided in the context of a foreign bank that, like BNPP, violated U.S. sanctions, but because it was not a U.S. citizen, the case was dismissed.
Not a U.S. person.
I'm sorry?
You said U.S. citizens because it was not a U.S. person.
U.S. person. Thank you, Your Honor. So the ATS claim falls as well. And then as to aiding and abetting, you don't have any of the elements that would bring about a claim under the standard of Halberstam. And we did raise as a threshold issue whether there's a preemption issue here, given the language in Jesner, that it would be odd to create a common law cause of action in that context. And here we've got Congress all over the field of terrorist policing, the criminal law, the attendant civil law violations. And here JASTA, which is aiding and abetting, is very clearly limited to attacks 2001 and later, and also where the FTO was the actor.
So let's unpack that argument a little bit. Are you arguing that the state common law claims are preempted under the reasoning of Jesner?
Yes, Your Honor. Yes, Your Honor.
That's not so clear in your briefing that the state, you suggest, you talk about common law generally, and Jesner is about creating federal common law. But how does that relate to existing state common law claims?
I think
whether that reasoning preempts the existing state common law.
I think
causes
about
of
it
action.
because of the role of Halberstam. The JASTA statute says you look to Halberstam as a form of federal common law that'll be applicable under the statutory regime.
Mhm.
It then says that if the attack occurred before 2001, it's not cognizable under Jesner. It also says you need the FTO involved, and Al-Qaeda was not an FTO until after this attack, several years later. And so if you look at that, it then does seem odd to say we're going to go to federal common law through a Halberstam claim
Well, it's not
and have this
federal,
claim
it's
proceed.
not federal common law, right? The plaintiffs are bringing a state common law claim. I mean, is there a distinction
I
there?
don't think there's a distinction because you're still in the realm of common law where Congress has really occupied the field, though I'm not arguing field preemption, we're discussing obstacle preemption. And so we think that's an important consideration given that language in Jesner and the way Congress has really very carefully calibrated these different causes of action and the concerns about international comedy and the fact that the policing of terrorism is a uniquely federal interest. And so that is why we think there is that threshold issue. Of course, this court doesn't need to reach it because the claims here fail applying the Halberstam framework. There is no, first of all, general awareness, as with Linda Hamilton in the Halberstam case. There, she knew that her husband was engaged in property crimes. And so knowing that and being tied together with those property crimes, she was charged with the reasonably foreseeable effect of the felony murder that occurred against Mr. Halberstam. Here, of course, there was no general awareness on the part of BNPP because there's no allegation that we were banking any terrorists, and then otherwise we're just back to this indirect connection through al-Shamal or through Sudan, where there's no allegation we knew that any of those entities were dealing with al-Qaeda. And there's a further layer here on the point that they haven't adequately pled that we were banking al-Shamal. They say we admitted that, and they say that in paragraph 90 of the complaint. But we didn't admit that. If you look at the statement of claims or statement of facts, there's no admission that the bank was banking al-Shamal. And even if we relied on what they say, the admission concerns the period 2002 to 2009. So 4 years and later after the 1998 attacks at issue in this case. So you don't satisfy the general awareness prong of Halberstam. And then going to the 6 factors, I think this court's decision in Bernhardt and the decision of the Second Circuit in Siegel are a fortiori here. There's no allegation that we had any encouragement of these attacks. In terms of whether anything we did was a significant factor, Bernhardt and Siegel are a fortiori. There, the allegations concern billions of dollars being transferred by HSBC, and the Siegel case, hundreds of millions of dollars. And the court said, but there's no link to that money to those entities and to the terrorist actors. Here, we don't even have amounts specified. We just have an allegation that there are accounts open. And it also says the allegation references accounts being open in BNPP Geneva, which is a separate sub and is not even the defendant here. So you have a further layer of lack of any connection between anything BNPP did and anything that's alleged to have happened in these attacks. There's no presence of BNP, the third factor, whether you think of that as transactional or, of course, no physical presence. There's no relationship with al-Qaeda. There's no, as we discussed, there's no knowledge of al-Qaeda's involvement. And we're also talking about, in both Siegel and Bernhardt, we were talking about years of activity by the banks, and that was insufficient duration. Here, plaintiffs are talking about a window of a few months between November 1997, when they claim we started, or when we started evading sanctions, and when the attack started in August 1988. There's no allegation that in that window, when accounts were alleged to just be being opened, that there was any material transaction related in any way to al-Qaeda. So just as in Owens, which is complaint by and large copies, other than just having this characterization of defeat sanctions and having general references to al-Shamal, this case should be dismissed, or the dismissal should be affirmed, just as the dismissal in the Owens case was affirmed. Unless your honors have questions, I'll say.
Judge Rogers?
No, thank you.
Okay, thank you. Mr. Dickens, we'll give you 2 minutes.
My friend stated that one of the reasons you can find there's no conspiracy here is because there was no intent. But intent is not required under a conspiracy, nor is the fact that the unlawful act giving rise or the unlawful act that's agreed upon is an unlawful act that gives rise to a private cause of action. It just says it's an unlawful act in which being agreed upon. Here, that unlawful act is the defeat of the sanctions that was set forth in November 1997. Now, this case is even worse than some of those cases my friend cites, Bernhardt and Siegel, because here, BNP rushed to the aid of Sudan, which was an impoverished country relying on funds and U.S. dollars for financial stability. Here, BNP came in for the sole reason to defeat the sanctions to make that profit. So when we're talking of questions about...
Aren't you in a little trouble if that's the sole reason? Defeating the sanctions?
I'm sorry, what was that?
Aren't you in a little trouble if that's the sole defeat sanctions? I'm still not sure how you get that to be a private cause of action. And contrary to what you seem to be saying, you have to have a private cause of action to be here.
And what our argument here is, Your Honor, is that the unlawful act that gives rise to the conspiracy, we got to look at it in two parts. What's the unlawful act? The unlawful act here is defeating sanctions, but that's not what gives rise to the private cause of action. It's what is done in furtherance of that conspiracy. So in Bernhardt...
Okay, and you're insisting that the embassy bombing was something they could, within the contemplation of a conspiracy to defeat the sanctions.
And the reason, and I'll cite the court to paragraph 8 of our complaint. This is a direct quote from Al-Qaeda. One of the stated reasons was to cease the campaign for the annihilation, humiliation that's being waged by the United States based on the blockades or economic sanctions. That was a stated reason, and it's not our role here to say that doesn't make sense. We must accept that as true and take those inferences in favor of plaintiff. And when we do so, and had those allegations, and it been shown in Bernhardt that indeed that act was in furtherance of the conspiracy, it would have met those elements. That is what was missing in Bernhardt and the other cases in which found there is no conspiracy. Here, this is a unique case. We admit to that. It's a unique case by which we have a terrorist organization telling us we bombed this.
Do you, in fact, have a factual allegation of the meeting of the minds involving both the bank and Al-Qaeda?
Well, what the case law tells us is we don't need a meeting of the minds between all of the different conspirators. All we need is a shared goal that was agreed upon generally. Al-Qaeda didn't need to know about BNP, and BNP didn't need to know about Al-Qaeda. With respect to, and the court asked some questions about Jesner and the ATS claims, our position is it's not as simple as saying, okay, BNP is a foreign corporation. There must be some analysis, and there must be some way to figure that out. That the Supreme Court didn't give any guidance. It didn't define what a foreign corporation is. And so we must look at how to analyze that, and diversity jurisdiction is not the way. Here, the sanctions specifically define who a U.S. person is. That's what gives rise to our complaint. U.S. person underneath the sanctions, which the complaint.
U.S. person, the closest you come in the statutory language is in a person in the United States. Is a corporation which is a corporate citizen in creation of a foreign country a person in the United States? Doesn't the Supreme Court say they're not?
Well, under the sanctions remedy, and the question once again is we must look at the actual allegations of the complaint, because what the court didn't say is, well, if there's a bank over there in headquarters somewhere else, they can never be a foreign corporation. First subject matter jurisdiction under the ATS.
Those are words that have common meaning. A foreign corporation is a foreign corporation. It's a corporation that's a foreign business. And it doesn't, you don't need a statutory definition of that. Those words are commonly used, just as a United States person is commonly used and has never been applied to a foreign corporation.
Well, it depends in the question of what we're looking at. for personal jurisdiction, we agree, but that's laid out in state.
Yeah, but in international law, the term a United States person or a Republic of France person or whatever is a common usage. And it is used to refer to citizens and nationals of permanent residents, persons who owe an allegiance to that nation. And I don't see how you get this foreign bank to be a United States person.
Well, in Jesner, obviously, they were concerned with foreign policy issues, and what
In
they
this
said.
case, I'm concerned with how you get this to be a foreign bank, get this to be a U.S.
What Jesner said is the political branches, not the judiciary, need to weigh in. Here, the political branch did weigh in. We have the executive branch stating, for purposes of violating these Sudanese sanctions, a U.S. person is defined as someone in the United States as well as foreign branches operating in the United States. So,
No, where did you get the as well as foreign branches operating in the United States? That's not in the statute, is it?
it's within the executive order that gives rise to the Sudanese sanctions in November of 1997.
And wasn't BNP Paribas held liable for the evasion of sanctions?
They were, yes, Your Honor.
So there was some governmental remedy against them.
There was, but that fact as well gives further support of there is not as large of a concern here for foreign policy issues when the government stepped in, held them accountable criminally, and fined them $8 billion because of it.
And haven't the plaintiffs here also benefited from the settlement between the U.S. government and Sudan for these claims as well?
Well, from a separate settlement.
So that was another public policy that addressed this underlying issue.
That's correct. Yes. Sir. Unless the court has any further questions. Thank you.
Case number 22-7111. Melchior A. George, appellant, versus Molson Coors Beverage Company USA, LLC. Ms. Brown for the appellant, Mr. Reedy for the appellee.
Morning.
Good morning. May it please the court, Carla Brown on behalf of Mr. George. Melchior George performed his job duties as a national account executive at Molson Coors so well that he earned their most coveted award from Buffalo Wild Wings, the Vendor of the Year award. His career at Molson Coors spanned the length of 26 years since 1991, and he developed close personal relationships with the stakeholders at that account. Following his heart failure and heart transplant, Mr. George's doctors assigned him temporary travel restrictions. Molson Coors then deemed him unqualified for his job. Molson Coors then refused every accommodation suggestion that Mr. George made, refused to consider him for the positions that he suggested, and even refused to speak directly to him about how he could service the territories that he had worked in for 8 years and earned the award. They also retaliated against him for taking medical leave and provided him a negative performance evaluation and terminated him. This is an appeal of the trial court's grant of summary judgment in favor of Molson Coors on behalf of Mr. George and with respect to Mr. George's disability claims under the DC Human Rights Act and his FMLA retaliation claims. If I can address the discrimination claims first, Mr. George is asking this court to vacate the summary judgment order and remand this matter for trial. A reasonable jury could easily find, given Mr. George's longevity with Molson Coors, his cultivation of deep personal relationships with his customer base, that in his case, it was not essential for him to have to physically travel to all of his customers in order for him to continue to successfully perform his job duties during this time of the temporary travel restrictions, a period of months.
Ms. Brown, so that might be kind of reasonable in theory, right? That someone could have these meetings by Zoom or over the telephone for some period of time. But doesn't this court, I mean, don't our cases suggest that we need to defer to an employer's, reasonable decisions about what is an essential function of the job? And here it seems that Molson Coors has, had, this kind of extensive travel as part of this job description for a long time. And it was always understood as an essential part of the job description.
With respect to yes, Your Honor, that it was part of the job description. Mr. George stated that in his deposition. However, Mr. George also provided information that the stakeholders would frequently visit him in DC, and that for just that period of months when he couldn't travel, he could continue to interact with some of them in DC. He had certain territories he rarely traveled to and might have been unaffected during this period of months when he couldn't travel. In addition to that, he suggested the use of temporary commonplace electronic and online platforms as a reasonable accommodation to reach those territories, again, that he was so familiar with that he'd earned the coveted Vendor of the Year award.
So but are you not disputing that that travel farther than 3 hours from DC and sometimes by plane was an essential part of the job?
Yes, we're disputing that travel for a period of months could be removed in Mr. George's case and still allow him to successfully perform, to relate to those customer bases, to continue to interact with key stakeholders. One of the items that Molson Coors relied on is the need for Mr. George to build rapport in those territories. He didn't need to build rapport any further. These were stakeholders who visited him as his home, who came to the DC area, people that he could continue to service just for a period of time on the online platforms, the ones that the court recognized in Solomon versus Vilsack. And a reasonable juror could easily find that those online platforms were sufficient, particularly given the time, particularly given now when online platforms are commonly used in a variety of areas. But the real issue is Molson Coors never talked to him about how he would service those territories, which ones he needed to travel to, where the stakeholders were located, what was required in those territories, something he knew well. He had two individuals who supervised him, one while he was out on medical leave, with a heart failure, learning that he needed a heart transplant, and a second one who had shared the other half of the country that he did not share, but who wasn't familiar with his territories at all. The HR person was responsible for accommodations as well as the new supervisor that he had. Neither one of them even spoke to him about which territories he could service, how he would service those territories. They never suggested any positions to him that he could perform otherwise. In fact, they refused to even take his calls. Mr. George requested 3 separate meetings to talk about his territories, to talk about how he could return to work. And with each of those meetings, the meetings were canceled without explanation, no call and no effort to reschedule the meetings. Mr. George then rescheduled the meetings, again canceled. They were determined to deny his return. It was a fait accompli. There's a legitimate dispute about what Mr. George could do given who he was in these positions. Turning to the FMLA claims, Your Honor, the district court recognized that Mr. Gick was the person who was named as Mr. George's supervisor during the periods that Mr. George was on medical leave. And the court even recognized that Mr. Gick expressed displeasure with Mr. George being out on leave. But the court found that Mr. Gick, quote, had not had a chance to bring his frustration to bear. The court improperly accepted Gick's statements that he was not involved in the termination over the contradictory statements of Molson Coors' own HR person who ran the accommodation process, who testified that she believed that she spoke to Gick about the ADA process, next steps, and, quote, moving forward with Mr. George's termination. The court did not credit the evidence that contradicted its factual.
Other than temporal proximity, what other evidence is there that this was retaliation?
The two emails from Mr. Gick, one in.
All right, that's the thing with which there is temporal proximity. But what, is there any objective evidence that's any connection between those two emails and the company's decision to terminate?
Yes, Your Honor, looking at, with respect to the two emails, the significance is the content of those emails. One in April 2019, where Mr. Gick expressed displeasure with Mr. George being out on FMLA leave, asking how long he could be out without having his position filled, and saying it was putting a strain on the team and impacting performance.
Was anything false about any of those? Be that as it may, have you connected that up to the termination? I understand that temporal proximity can be a piece of evidence, usually corroborating something else, but it can be a piece of evidence. But what else is there to connect those emails with the termination?
Well, Your Honor, I think looking both at the temporal proximity and the content of the emails together, that shows the animus. That Mr. George, February 2019, is out on medical leave. 1 month later, he receives a very critical evaluation from his supervisors, who neither one of whom really supervised him because he was in and out of medical leave for Mr. Gick, and with Ms. Winter, he wasn't there.
You're saying he was unsupervised while he was on medical leave?
No, I can't say that, Your Honor.
That seems to be what the argument was between the briefs.
The argument is he had a supervisor who retired, and then Mr. Gick came in the picture. And once Mr. Gick, during that period of 3 months, really, Mr. George was in and out of medical leave. When Mr. Gick wrote his evaluation, he neither focused on his work that led to the Significant Vendor of the Year award or even the award. 1 month after that, Mr. Gick openly expressed the displeasure in the email. And then in August of 2019, while Mr. George is still on leave, he's on leave during this period, Mr. Gick implores Ms. Nellens to come up with, quote, a better plan for dealing with Mr. George in the context of him being on FMLA leave. The following month, Mr. George goes into the accommodations process, where Molson Coors spends weeks denying him, rejecting him, refusing to speak to him with respect to the meetings he set up. And then roughly 2 months later, the day before Thanksgiving, he's terminated. I would just say the DC Human Rights Act and the Family Medical Leave Act are designed to protect employees like Mr. George, who perform their jobs in an exceeding manner and just need a brief period of accommodation to continue to perform their jobs.
So are basically saying that summary judgment here was inappropriate because the accommodations process was a farce?
Yes, in part, Your Honor. One, that he could perform his job duties with an accommodation.
No, I'm not talking about in part. All of your arguments to us today seem to say that the employers refused anything he asked for, including meetings. Yet the way that part of the record I've looked at reads is not quite that. He may not have gotten responses he wanted, but he conveyed his ideas, and the company simply did not accept them and gave an objective reason as to how it defined this position he held. That's the way I understood what happened here, but today you're sort of arguing that he asked for meetings, they were canceled. He asked for consideration of certain things. There was no discussion about it, etc.
I think I'm not sure if it's frozen. Yes, Your Honor. That's exactly what we're saying. That's what the record supports, that that his considerations weren't discussed. Both Ms. Nellens and Ms. Winters testified that they never engaged in any conversation directly with him about the territories that he could work in or how he would service even the regional chain position that he suggested a demotion. I don't know if that answers Your Honor's question, and I see that I'm out of time, over time at this point.
Judge Rogers, did you have a follow-up or?
No, I may ask you later. Thank you.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the court. My name is Hans Reedy, representing Molson Coors, and I'm here with my colleague, Sarah Belger. The undisputed facts in this case, undisputed record evidence, establishes that travel was an essential function of George's job. George admitted in his deposition that 40 to 50% of this sales position centered around travel. The job description itself, that actual business record, is in the record evidence, and it establishes that 60% in that posting. Gene Winter, who covered the western part of the United States in the same role with Mr. George covering the eastern part, covered for Mr. George when he was out for his illness, and testified that she had to travel at least 3 weeks out of every month. Mr. George testified in his deposition that in-person interaction with brand and product at the restaurants, as you could imagine in this on-premise sales position, it took in-person interaction. And in addition to that, George stated in his deposition, testified in his deposition, and he gave us this reason also, and it's really well reflected in the record, particularly the ADA accommodation packet, which just shows the extent that Molson Coors went through in this back and forth. And there were emails back and forth, and there was a documented conversation, and there were other positions that were actually analyzed, following Molson Coors policy to a T. And it's significant, detailed evidence that demonstrates that Molson Coors engaged in this interactive process in absolute good faith, and also per company policy. Plaintiff argues that appears to take issue with the fact that Mr. George wasn't always looped into all this. Well, we had an HR specialist per policy corresponding with other individuals to determine the job requirements of these two alternate positions. And those were both determined also, and the form is in the record that there could be no reasonable accommodation because they required travel and they required in-person interaction and presentations. And Mr. George also, like I said, his daughter was in school here. He could not, that was a self-imposed restriction that he had there, that he wouldn't consider any other position outside of the DC area. And also the court, there was no temporal proximity to these two GIC emails that are cited by the plaintiff. Those happened in August of 2000. The latest one was in August of 2019. And what Mr. GIC is trying to figure out there's no fill in that email. It says cover because as a manager, he's trying to figure out how to cover the role. And that's all he is stating there. And then the termination does not occur, and it occurs after short-term disability is completely exhausted. It doesn't occur until November.
Yeah, how long was it between the emails and the termination? It
was September, October, November, 3.5 months from the last email that Mr. GIC sent. And also Mr. GIC, there is no evidence that Mr. GIC it's uncontradicted in the record that Mr. GIC did not make the decision to terminate. He was spoken to during the process, but he did not make the decision. And the decision was made per company policy. And ultimately, there was no involvement from him in that ultimate decision. But he exhausted his short-term disability. He couldn't come back to work. He stated this. His doctor's records, which were also relied upon and are in the packet, specifically say that he can't travel for more than 10 to 12 hours a week. Well, he brings up distributor positions, but he also acknowledges that if you work for a distributor, you're going to be driving all the time in a car. So that didn't work out.
So So even if we accept that travel is an essential function of this job and the other jobs, I mean, what I understand Ms. Brown to be saying is that it wasn't essential that that Mr. George be traveling for some limited period of time, that it wasn't essential that he had to be traveling at all moments of his job, and that he could have, for some short period of time while he was recovering, not traveled as extensively. I mean, what is your response to that argument? Because that's sort of what I understand, Ms. Brown.
My response to that argument is it's not supported whatsoever in the record. It's completely contradicted by a mountain of evidence in the 88 packet and so forth. And there's analysis that goes into it. And for example,
that travel is essential, like at all moments of this job?
Not at all moments, no, but in high percentages of it. I mean, it's an essential element. It's very competitive. There's record evidence of that. And that's what distinguishes it from any of these other cases that are cited. We're talking about outside sales person. And so you have, as Gene Winter testified, Anheuser-Busch is at Buffalo Wild Wings. They're a huge customer too. We need to be there in person. Everybody acknowledges that. We look to these others, sure, it's not 100%, but this is a strict requirement imposed, unfortunately, by Mr. George's, due to his unfortunate health condition, to his, by his doctor.
So basically, excuse me, go ahead, Judge Rao.
Oh, no, I'm fine. Please continue.
So basically, your position is there is this job, here are the elements, end of discussion. And of course, the COVID period required all of us to make adjustments that we might not have otherwise made. And some experience developed in that regard was good. So I understand in person, but he was the head for this region. Were there no sort of deputies or assistants who could fill in the in-person travel for this period of time?
No, there weren't. I mean, no.
And we know that because?
Well, the law that applies states that it's not an employer's obligation to kind of have to have two people to fill one job.
No, of course not. That's not the question.
Okay.
The point simply is that a lot of requirements that all of us assumed were part of our job had to be adjusted in due of circumstances beyond our control. So you could say, well, a heart attack and recovery is not that, but it's not exactly, sorry for the double negative, not comparable either. It's one thing if he were going to be off, I don't know what a short period means here, but we have deputies all over. And, you know, at the highest level, we've had vice presidents fill in for presidents historically. Now, everybody wants to see the president. They want the president on the scene, but sometimes that's not always possible for whatever reason. And Coors is saying, and I agree with the inference from Judge Rao's initial question to appellant's counsel that, you know, our laws, we don't define jobs for employers, that the question is, has the appellant here met his burden to show, to overcome sort of that presumption that we accord to the employer's job definition?
Yeah. Thank you, Judge Rogers. Would you like me to respond, Ms. Mel? I don't know if you're.
Was there any evidence in the summary judgment proceeding that there was any such subordinate available to fill in for him?
No, there was no evidence whatsoever.
He's essentially an account manager who has to manage the account, right?
Yes, and there is evidence that he raised in the interactive process the alternate roles that he thought he could potentially do. And then in the ADA accommodation packet, this is where Molson Coors absolutely met its interactive burden. It analyzed the points of call that he had and where in the United States that was. And he raised two other positions in their forms where Ms. Nellens conferred with G. Winter, who knew the details of the job and whether it could be. And it was said, no, there was no accommodation that could be had. One other point I wanted to raise here.
No accommodation that could be made by the company as distinct from what the appellant could do on his own. Namely, move and things like that.
And other positions were analyzed, including the one down to that would have required travel beyond 3 hours down to Virginia Beach, other alternate roles. And those were analyzed and based upon the canvassing of company individuals who knew the job requirements and the discussions and acknowledgments of Mr. George reflected in the record, he could not perform those jobs and couldn't be traveling. And what he kept saying was that he thought he would be ready to work in May of 2020. He went out on FMLA leave in February of 2019. And so FMLA leave was exhausted. I mean, Molson Coors went above and beyond what the FMLA and ADA required and kept him. And then he was ultimately approved for long-term disability. And that's in the record, which demonstrates he signed that he could not perform his job. That's why he was approved for long-term disability. And so this is one where Molson Coors absolutely empathizes with the serious challenges that Mr. George faced. I could get more into record details and refute, for example, the fact that his reviews were consistent. He had consistent and negative in some areas reviews, and that's all he had for constructive criticism. And that just addresses the retaliation argument, which is exceedingly tenuous.
I see we're out of time. If my colleagues have any further questions?
No, thank
Judge
you.
Roberts? Okay.
Thank you very much.
Thank you. Ms. Brown, we'll give you 2 minutes for rebuttal.
Thank you very much. Your Honors, I would just ask the court if the court looks at the record, it's clear there was an absence. Ms. Nellens has notes of the accommodation process. There's an absence of even a single suggestion by the employer on how to accommodate Mr. George. ACA versus Washington Hospital Center tells us that there's an onus on an employer to do something to participate with regard to the accommodations process, even to make suggestions on reassignments. But Molson Coors did none of that. It was all Mr. George suggesting different positions, 4 positions in the area, including his own, that he tried to make accommodations within or suggested. Molson Coors' suggestion that Mr. George couldn't travel is an attempt to obfuscate that they were not willing to work with him on any jobs, not the 4 in the area that he certainly could have handled with accommodations, and none outside the country. They made none anywhere else, no remote positions, nothing. They made no suggestions whatsoever. I'm sorry, Your Honor, I did not hear you. I would just note, again, as to the FMLA, the significance of that ADA process where the employer refused to do anything for him, refused to talk to him, refused to even pick up the phone. Mr. George pursued that accommodation process with the same tenacity that he pursued his job that led him to get the Vendor of the Year award. Mr. Gick tells Ms. Nellens, come up with a better plan. 1 month later, she does. She puts him in this accommodation process where the employer does nothing but refuse to talk to him. It's very significant that the employer never spoke to him about the territories. He was the only person at the company who knew how to service those territories and could do it well. They refused to talk to him, to pick up the phone on those 3 occasions that the accommodation or discussion was canceled. As to that, and for that reason, Your Honor, we're asking the court to vacate the court's summary judgment order. A jury could find that Mr. George in his case could perform his job duties, that the company refused to accommodate him or to consider his reasonable proposals like certain services on electronic means, and that they retaliated against him. Thank you.
Thank you, Ms. Brown. Case is submitted.